you. You were also paid $1,800 by my office, correct?
Yes, sir, for my deposition fees.
And for today, you're being paid another $10,000 to prepare and appear here and testify and go back and forth. Is that fair?
I think that's reasonable, yes, sir.
Could it be higher than that amount?
I don't think so. I think that's a reasonable estimate.
So my estimate is about $40,000, correct?
Yes, sir, I think that's very reasonable.
And in the past 29 years, you testified at your deposition, I can ask now, isn't it true that in 70 to 80% of cases, you testified on behalf of the defense up until recently, correct?
Yes.
And there's a well-known lawyer that we all know, no need to mention names, but recently he's been giving you some more work, so your 70 to 80% has gone down to 60%, correct?
More work on the plaintiff side, that's correct.
And as far as the attorneys, Cardi B had an attorney before Mr. Kossoff and other lawyers. In working with their firm, you worked in 5 other cases with them?
That sounds about right, sir, yes.
And with their new law firm, Davis, Wright, and Tremaine, with Mr. Peterson, Mr. Lamb, and all the other attorneys involved with them, you worked in 15 cases with their office, correct?
Objection. Same status.
Yes, over the past 20 years or so, that's correct, though I've never worked with these particular attorneys before.
And would you agree that in 90% of cases that you were hired in, you basically remain the expert on the case and you don't withdraw, correct? About 90%.
I apologize, I don't recall a case in which I have withdrawn.
So are you saying that every single time the defense hires you in a case, you remain the expert in that case without giving them before you testify?
Objection. This states.
Is that what you're saying, sir?
This is me.
So when you were hired by Cardi B's office, by her lawyers, when were you hired?
I believe it was sometime early in 2023.
And when you were hired in 2023, did you ask, well, strike that, did you examined Imani Ellis in 2023, correct? Or was
Yeah.
it 2024? Sorry.
Sorry, I mean to interrupt you, sir. I believe it was July 21st of 2023.
Did you ever do any type of examination on Cardi B at any time? As to what is the basis of this claim? What is Imani Ellis's claim? Why is she here in court?
My understanding is that she felt that she was verbally mistreated by Cardi B, including foul or demeaning language, that Cardi B touched her face with a long fingernail and caused some injury to her face, and that also resulted a month later in Ms. Ellis being fired from her security job.
Okay. Do you know, in psychiatry, do you treat patients that deal with assault and battery?
In my patient care practice, putting aside legal matters?
Yes. Career since 1994 as a psychiatrist?
A few hundred times, from very simple to extremely severe injuries.
When you say simple, what is an example? What are you saying to us?
Yes. So by simple, I don't mean to say it's not important or it's not serious to the person, but I mean, for example, let's say somebody being pushed or hand on the shoulder in an aggressive way, and being hit over the head with clubs and pistol whips, a variety of things, stabbed.
And when you treated the various patients, would you treat them more than once? The ones that you're speaking of?
Typically, I mean, it depends on the setting. As a medical doctor, I spend a lot of time in emergency rooms. So they're overmark them on a repeated basis. Some of them I would treat for many years, although those tended to be individuals with major mental disorders like bipolar or schizophrenia.
Okay, and if you could just look at the other binder on your left, please.
Pardon me one sec, sir.
Sure.
Yes, sir. Where should I look?
Yes, if we can look at Exhibit 1-003.
I'm there, sir.
At the time of your deposition, had you reviewed this page?
Objection. It's not beyond the scope of your right.
As best I recall, sir, I had not reviewed this particular page.
Do you remember in your deposition, I asked you if you'd reviewed all of Miss Imani Ellis's medical bill? You remember that?
I apologize. I vaguely remember that, and I don't remember what my answer was.
Is he designated for medical? Then I will go down the track.
Thank you. If we exhibit number 2.
Exhibit number 2, sir.
You reviewed the medical records bills of Dr. McKinney, correct?
Yes, I have done so recently, but I did earlier in this case.
And we went over this here at the time of deposition, and you expressed that for purposes of workers' compensation, the treatment was reasonable, but maybe for this case it's not. Do you remember testifying to that, Doctor?
Objection beyond the scope of your right, and also beyond the scope of the executive designation.
Do you have his designation?
It's in the trial. Trial.
Wasn't it right?
Staff 8.
The difference is the same.
As far as any type of physical injury, isn't it true that you are not giving any type of expert opinion about physical injury, correct?
Aside from her inconsistent reports of whether or not she was actually touched on the face by the fingernail, that's correct, sir. I'm not a plastic surgeon. Other than that, I'm not giving any testimony with regard to physical injuries.
And when she came to your office, did you examine her face to see if she had a scar?
As I do
So
with,
yes or no? I'm sorry.
well, I observed her across the table for several hours. I didn't specifically examine her face.
Did you have an intention to look for a scar on her? Yes or no?
Yes.
Did you physically go up to her face and look to see if there was a scar?
No, sir.
Are you giving any opinions about Miss Imani's physical scar on her face, whether she has one now, she had one from this incident, anything to do with her plastic surgery? Are you giving any of the opinions about that?
Objection, incomplete hypothetical, also beyond the scope.
It's the
Also
same.
recommended.
And in formulating your opinions, did you review Ms. Imani Ellis's medical records?
Yes, sir, and those were extremely important to me, actually.
And you reviewed the medical records from Nicole McKenzie, is that correct? Is that her? Do you remember that?
I haven't recently, but I have in the past, yes, sir.
You can look at it. Did you review Exhibit 2?
Yes, sometime before my deposition, but I've not looked at this.
And you reviewed Exhibit 3?
Yes, sometime before my deposition, but not since.
Okay, and you reviewed Exhibit 4? And Exhibit 5?
Let me take a look here. Pardon me a second.
Objection compound.
Overruled.
As best I recall, yes, but not recently.
And in formulating your opinions, did all of these exhibits assist you in your formulating opinions and coming up with your opinions for us today?
The Kaiser records were extremely important because she had several visits and didn't report a single emotional problem, didn't ask for any care related to this case.
Objection, non-responsive.
So it's a yes or no question. Did you rely on the records in forming your opinions?
Only the Kaiser records.
I didn't ask you about the Kaiser.
Oh, I'm sorry, you had asked me about the Kaiser records earlier. You mean just the ones that I'm looking at in the notebook?
I never said the word Kaiser. I'm sorry. I apologize.
I'm sorry, I guess when you said medical records, that's what I was interpreting.
Yeah, I'm talking about the medical records from Dr. McKenzie, the psychologist, the medical records from Dr. Avila, a psychologist, the medical records from Dr. Mulliken, a plastic surgeon, and the medical records from Dr. Norman, pain management doctor. Did you review these records? You testified a moment ago, yes. And then the question is, did you use these 4 medical records in formulating any of your opinions that you testified to today here in court?
No, sir.
Okay, so when you said there was inconsistencies, didn't you mean that, well, strike that. When you said there's inconsistencies, you found those in the medical records that I just asked you about? Isn't that true?
Maybe I had previously, I don't recall if that's in my deposition testimony, but I did not consider those in formulating my opinions for today. It was the Kaiser records.
Okay, the Kaiser records that you're speaking of, isn't it true that the Kaiser records, any medical treatment that Imani Ellis received at Kaiser, it has nothing to do with this case. It has nothing to do with assault and battery.
Objection.
It's something totally unrelated, correct?
Objection, speculation, hearsay.
So we're proud as well. Sustained.
Why did Imani Ellis go to Kaiser Hospital?
Objection, speculation, hearsay.
Sustained.
Do you know why, from reading the medical records and bills, do you know why Miss Imani Ellis went to the Kaiser Permanente Hospital?
Objection, six, objection.
Overruled. You know the answer?
Yes, Your Honor, the answer is yes.
Okay. Why did she go to Kaiser Permanente Hospital?
Same objection.
Overruled.
Well, April 2022 was for an annual history and physical comprehensive. November 2022, comprehensive history and physical. April 2023 with the day was for reported hand pain.
Everything that you just told us right now about Kaiser Permanente Hospital, as a medical doctor, and in reviewing all these records that testified you read, wouldn't you agree that those medical treatments have nothing to do with this incident? Agreed? Yes or no?
Objection, very ambiguous.
Overruled.
I disagree, they're extremely important.
I didn't ask you if they're important. I agree they're important. Going to a hospital is important. My question is, if the medical treatment that was received at Kaiser Permanente Hospital, if it has any relation to medical treatment received by Imani Ellis related to this incident that occurred on February 24th, 2018. Was it?
For my purposes, yes.
Okay. So are you telling us that Miss Imani Ellis went to the hospital in 2022 and 2023 because of injuries related to this incident? Is that what you're testifying to, doctor?
No.
Okay. I understand what you're saying. What you are telling us is you use some of the medical records from hospital to formulate some of your opinions in this case. Is that true? Maybe
Yes,
I'm
sir.
wrong. Okay, that's true. You use that for your different type of studies, your MMPI studies, and all types of different testing that you did, correct?
Objection, very individuals.
Over 5, it's the same.
But just so we're clear, the actual treatment didn't have to do with assault and battery or a physical injury. Is that right?
Objection, very individuals.
It's been asked and answered several times.
All right, and then I want some clarity on the other 4 documents. The psychological, well, let me ask you this. As a psychiatrist, do you believe that psychological care with no medication is a respected medicine?
As a general principle, yes.
Have you referred your own patients to receive psychological care?
Oh, innumerable times, yes.
And whether it's a PsyD or PhD or some other type of psychologist that's licensed, you agree that patients can receive medical care from those types of professionals and actually benefit from that type of care. You agree?
Well, it's not medical care, but I do agree that they can receive very helpful, effective mental health care.
So, are you saying mental health care is not medical care?
Objection,
Benefit from mental health treatment with no medication.
that means I'll be hypothetical.
Overruled.
For the appropriate indication, yes, sir.
And how does it help if they go to a psychologist and they talk about their problems from your perspective? You're a psychiatrist. You are the man who would know. So when a patient goes to a psychologist and they talk about their problems, they explain their problems, why does that help the patient? Why?
Objection, very individuals.
I don't know that it's relevant, so if you can establish some foundation as to why we're talking about other patients.
Did Honest receive psychological treatment in this case, based on your review of the medical record and medical bills? True. She went to 7 treatments with Nicole McKenzie and other doctors from her office. Is that true?
Objection, beyond.
All right, sir, yes.
And she went to Dr. Avila, another psychologist. She went to his office and got treatment from other providers that work under him for a total of 12 treatments, correct?
Objection, beyond the scope of this exercise.
Overruled.
That sounds about right, yes, sir.
And those 2 psychologists, setting aside this case, is there any reason why you as a professional would not refer a patient to these 2 psychologists?
Objection.
I withdraw the question. If we were to talk about, do you remember at the time of your deposition, you said to me that you testified under oath that you worked alongside Dr. Mulliken in cases before? True? About 10 times?
Objection, states this.
Overruled.
Well, when you say alongside, I've been on the same side and on the opposite side in several legal cases, not like next to him, surgery.
I understand. But you worked alongside him, meaning you've worked on the same cases in about 10 different times, correct? That was your testimony.
Yes, sir, it's 10 on the same side, or 10 in total on both sides, but accept whatever you said.
Right. And you're affiliated with UCLA?
Not anymore. I was a professor for 16 years, but not anymore.
Okay. And Dr. Mulliken is also affiliated with UCLA? Is that right?
I don't know if he's currently affiliated with UCLA or not, sir. He certainly has excellent qualifications.
Right. You said that at your deposition. Your words were, he has very impressive credentials, correct?
Yes.
Do you know Dr. Mulliken to be a clinical associate professor at UCLA?
Objection, speculation, beyond this expert's designation.
At your deposition, you said that you cannot say that the diagnosis was malignant. Do you remember testifying to that?
Yes.
And what does that mean?
You mean, what is malingering?
Well, yeah. Sure.
That, or by saying I couldn't diagnose it.
Why don't we start with what does malingering mean?
Psychiatric association. It's not a disorder, but it's a diagnosis, which refers to a pattern of intentional exaggeration, fabrication, or other manipulation in a legal context for secondary gain. For example, in a criminal case, it could be trying to appear psychotic to avoid criminal punishment. In a litigation like this, typically for monetary gain.
And you testified at the deposition that you cannot say that the diagnosis was malingering. You remember saying that?
Ms. Ellis, absolutely. I did say that, sir.
Do you remember Ms. Ellis, you had an encounter?
Yes.
Do you remember telling Ellis that you were sorry about what you did? You
Yes, based upon her description, I told her I was sorry what she went through and it was a meter.
And that you did was in 2023, 5 years later?
Yes, sir.
Would it have been beneficial to have done or testing in all the different shortages there?
Is also equally beneficial.
Okay. And do you remember I asked you about discovery? If you had reviewed any discovery and you said you had not. There?
Yes, sir.
Okay. And you actually asked that the defense provide you with the discovery so you could review it and that you would then give us additional opinions. You remember testifying to that in your deposition?
Objection, this states this.
I don't recall, but I know I said that if I received additional information of any type, I'd happily review it, consider it, and it could modify my opinions.
Have you received those discovery responses?
No, sir.
Do you remember also testifying at your deposition that it would be beneficial to your opinions to see Imani Ellis a second time? Do you remember testifying to that?
Yes.
And that if you saw her a second time, that it could further modify your opinions in this case, correct?
Objection, this states this.
Over.
Potentially, yes, sir.
And between 2018 and 2023, before you saw Imani Ellis, between that 5-year time span, her psychological or psychiatric condition could have changed, correct? She could have got better. She could have recovered, right? True?
I'm sorry, between 18 and 23?
Yes.
That's certainly a possibility.
Okay. And when she saw Dr. McKenzie for 7 visits and other doctors that work in Dr. McKenzie's office, those 7 visits, you said that psychological care helps. Maybe it helped her.
Objection calls.
Correct? Do you believe Ms. Imani Ellis benefits psychological care she received from McKenzie? Yes or no? And she also received, from your review of the medical records, 12 visits from Dr. Avila's office and staff. Correct? You testified to that. So would you agree that 7 plus 12 is 19 visits of psychological care? True?
Yes, I feel very confident in that, yes.
Okay. Appreciate that. When you refer your patients out for psychological treatment, do you usually give a limit on the course of care, or maybe 5 visits, 10 visits, 12 visits, or you just refer them out to psychological providers?
I'm usually quite precise, but it also depends on the type of psychological care or psychotherapy. Some are time limited on purpose. Others could go on over the course of somebody's lifetime.
All right, so why don't we focus on what his opinions are?
Yes, Your Honor. Thank you. Okay. Also, we talked about the distinction in your deposition between factual opinion and psychiatric opinion. And you said that you cannot. You remember testifying that?
Yes.
Break it down is you don't know this occurred. Is that fair?
Outside of a psychiatric context, that's correct. Actually, it's none of my business to determine what happened.
Okay. And isn't it true that you don't know if Miss Amani Ellis was assaulted and battered by Cardi B? You just don't know, correct?
Factually, that's correct, sir.
And you also don't know if Imani Ellis was cut on her face by Cardi B. You don't know that, correct?
Objection beyond the scope of this evidence.
Assistant.
Have you ever spoken to Cardi B at all in the course of this case?
I've never spoken to her.
Version of what happened in this case. Would that help you in your expert opinion?
I'd certainly be happy to weigh that and give it consideration, but my focus was on emotional injuries of the plaintiff, Ms. Ellis, not on an evaluation of Cardi B.
Understood, but would it have been beneficial to at least have her version of what occurred in the case? Can you help you?
It's a privilege to.
You testified earlier as to your understanding of the facts of this case. Could you please explain what sources that's based on?
I'm sorry, I'm having trouble hearing you.
I'm
sir.
sorry. You testified earlier as to your understanding of the facts of this case. Could you please explain what sources your understanding based on?
Yes, so it's based upon my review of Ms. Ellis's deposition, the available medical and mental health records I reviewed. Again, with the understanding several of them I haven't reviewed recently. It's also based upon my detailed audio-recorded several-hour interview with Ms. Ellis. And again, in the course of doing my interview, I accept hypothetically at face value that what she's telling me is correct. And then later I form my opinions, which may include opinions regarding symptom validity. But it's not my role to make a factual.
The facts come from Ms. Ellis, or statements that Ms. Ellis made. Is that correct?
Yes.
And does that make sense to you that you would rely on Ms. Ellis's own statements in forming a diagnosis or lack of diagnosis as to Ms. Ellis?
Objection outside the scope.
Over.
Well, if it was a patient care setting, you typically rely only on what the patient tells you and accept at face value. The person's there for help. In a legal context, it's not appropriate for me to accept what somebody says at face value without corroborating it against psychological testing and available records.
You testified that you did not formally diagnose Ms. Ellis with malingering. What does a formal diagnosis of malingering require, and why did you not? scratch that. Why did you not diagnose Ms. Ellis with loitering?
Because although Ms. Ellis meets the fundamental criteria from a psychiatric standpoint of gross symptom exaggeration or outright fabrication and a pattern of inconsistencies across information, she's had so many traumas in her life, both growing up and other losses and traumas around 2018, that I can't rule out that she has some sort of emotional problems at a mild level, but they just wouldn't be related to this case. Yes.
Is that correct? In your professional opinion, what is the likelihood that Ms. Ellis after this date would suddenly develop emotional or psychological injuries related to that incident?
Objection, vague and ambiguous, unintelligible, compound.
I'm sorry, I didn't hear.
Overruled.
It makes no reasonable sense, and there's no significant likelihood that that would be the case from a medical standpoint. Again, the incident itself, taken at face value, constitutes a situational stressor, a stressful interpersonal interaction. Certainly does not constitute a trauma, as I've discussed. And for somebody to not have a psychiatric disorder and emotional injury for 5 years thereafter, but have significant evidence of symptom manipulation, and also to have the resilience to, by her own accord, report not have psychiatric problems from all the real trauma she has had in her life at other times. It makes no sense that she would suddenly develop it at this point.
Give me just a minute. No further thing.
All right, recross.
For any type of other types of injuries that you brought up, someone who was shot at school, a family member got sick, all these other things that you brought up, where did you obtain that information from?
Objection, vague and ambiguous.
Overruled.
And it's also outside.
Sustained.
Do you see any other psychological records or bills related to Imani Ellis prior to this incident?
Outside the scope.
You generated a report, correct?
So there's basically one line of questioning related to whether or not your client had a later onset of symptoms. I think you're limited to that.
Yes, sir. When you said, when counsel just asked you some questions about inconsistencies and malingering, you said there were inconsistencies. Where were there these inconsistencies? Was it the time when you interviewed her one time, or was it in the medical records?
Objection, outside the scope.
Overruled.
As I had tried to explain, it was a combination of my review of the records, the psychological testing, and my interview, comparing those as well as intrinsic validity issues within some of those sources.
Which medical record shows inconsistency? Which,
The extremely important Kaiser medical records.
what does the Kaiser medical record say that's inconsistent?
that in April 2022, went for complete physical. She specifically denied any kind of mental health issues, specifically denied anxiety, sleep problems, had no reported mental health problems, no request for care. Same thing in November 2022 with Dr. Ahmad. And then in April 2023, when she went in for pain with nurse practitioner, they also did a review of systems and asked her about symptoms across the board, which is typical for Kaiser. Absolutely no emotional problems whatsoever, no request for mental health assistance.
Okay. So are you telling us that when Imani Ellis went to Kaiser Permanente on the date respectfully, when she went there for vaginal discharge, she should have told that doctor that she had psychological issues. Is that what you're saying, doctor?
Objection to
Yes or no?
Oh,
Or can you just
I don't
answer
think
the
he said he
question?
based his opinion on that record, Counsel.
You reviewed this record, Kaiser Permanente, correct? You reviewed it. You just testified about it. 161 pages of records. And you said that these records show inconsistency. And now my question is, are you telling me that my client went to Kaiser Permanente for vaginal discharge on November 29th of 22, and at that visit, she's supposed to tell the doctor that she has psychological problems? Is that your testimony, doctor?
Objection, argumentative.
Assistant.
Are you telling us that every time someone sees a doctor, medical doctor, for a cough, sees a podiatrist for
Assistant.
what do you mean by inconsistencies in the Kaiser record? Tell us in your own words.
I just mentioned as example 3 key entries where she went to. 2 of them were for history, physical, and general checkups, where everything was covered.
Show me in the book. Show me in the book. Book.
Okay, why don't you finish the answer before you ask the next question?
So
What are you doing?
practitioner Leon April 2023. Were these problems with insomnia or anxiety, which covers a significant aspect of her symptoms.
Doctor, in the blue book, under Exhibit 212, the more you're more than welcome to look at it and show it, so
Objection.
that we know the truth.
Objection, Your Honor.
I withdraw the question. Let's go to another issue, Doctor. So, if the plaintiff's emotional injury ended before she went to Kaiser, would you agree that there would be no inconsistency because the psychological injury ended prior to that medical visit? You agree with that?
Objection, speculation outside of the scope.
In a reasonable sense, it's not possible.
Why is it not possible? Why can't she recover? She could have recovered before she went to the Kaiser. could have recovered, couldn't she?
Which question would you like me to answer?
Could Miss Imani Ellis have recovered in 2021 or 2022 before she went to Kaiser Hospital? Is that possible? Yes or no?
Objection, incomplete hypothetical.
Overruled.
Taking her symptoms at face value, it's not possible and it's contradictory.
So if in her mind, in her brain, she felt that she recovered after seeing these psychologists, why would she tell Kaiser that she has a psychological problem?
She did an exam with him in 23? When did she see him?
Yes, that is.
Okay, and you're saying that she recovered prior to that, but then had the onset of symptoms when she's with him?
My question is if the plaintiff recovered in 2022 before she went to Kaiser Permanente Hospital, she had recovered. Ellis saw you. Did she tell you she was still experiencing emotional injuries from this incident?
Yes, in both the interview and particularly the testing.
And when she told you she was suffering from emotional injuries, did she believe that you're a psychiatrist? Did she know that?
Objection, speculation.
Sustained.
Did you disclose to Imani
Okay,
Ellis?
we're beyond the scope here. Why don't you focus on what was in the redirect?
You said there were some inconsistencies in the Kaiser records. Isn't it true that when Imani Ellis went to Kaiser Permanente Hospital, she went there for reasons other than psychological reasons?
Objection, asked and answered.
Sustained.
In fact, aside from, well, strike, I'll withdraw that question. The first doctor you said, Dr. King, that she saw? Dr. King, right?
It wasn't the first doctor she saw, but it was first of my 3 examples. That was April 2022, sir.
Fine. When she saw Dr. King, where did she see Dr. King from?
Objection.
I think we've fully exhausted the scope of this line of questioning. Do you have anything else?
Aside from the inconsistencies that you reviewed, well, actually, let me ask you. The inconsistencies that you're telling us about in the records, in the Kaiser records, these are non-psychological records, correct? Is that fair? I'll close with this.
Objection.
If you say yes to that, we're done.
Objection, this
I just want the truth.
Overruled.
Yes, sir.
No further questions.
All right. Any questions from the jury? I don't see a hand. All right. Can this witness be excused?
Yes, sir.
All right. Thank you. All right, folks. That's going to bring us to our afternoon break. Why don't we get back together at 3:25? In the meantime, please do not discuss the case with anyone, including other jurors. Don't form any opinions. If you do any research, we'll see you at 3:20.
office?
Yes,
And what floor was that on, if you know?
4.
Okay. And did the building have a receptionist?
Not a receptionist.
Okay. Do you recall an incident in February 2018 where there was an argument with a security guard?
Yes,
Okay. And is that security guard in the courtroom?
yes.
And could you point her out, please?
Miss Ellis?
Thank you. How did you learn of the incident?
I was in my office, in my office's office, and then heard a lot of yelling. So I immediately got up, ran down the hall, and went out into the hallway.
Do you have a clear memory of what happened next?
Yes,
Any particular reason that you have that clear memory?
it's never happened before.
Okay. And what did you do after you ran down the hall towards the yelling?
As soon as I got into the hallway and realized what was going on, my receptionist was between the plaintiff and the defendant, and there was a lot of yelling, a lot of finger pointing, and at one point, my receptionist was struck, not hard, but I remember it was like on the shoulder kind of thing. I think it was her right shoulder. And there was a phone in the security guard's hand, and the phone kept going back from the ear to point and then back to the ear. And at one point, kind of both hands were kind of flailing, but not closed fists or anything like that. More swatting.
Did your receptionist show you a cut on her forward afterwards?
I believe so. Very minor.
Okay. And what is the receptionist's name, the woman who was between Ms. Ellis and Cardi B?
Tiara.
So you see all that, you've gone out into, and I'm sorry, where was this? Was this in your office or in the hallway?
The main hallway of the 5th floor, just right outside the elevators.
And you hear yelling, you open the door, you see what you've described. What happened next? Let me ask, what did you do next?
Tried to de-escalate the situation, separate the two, and get our security guard back in the elevator and off the floor.
Do you remember anything that you said in trying to de-escalate?
I remember repeatedly, I was trying to match sort of with body, language, the intensity of it to get across the point that this was not okay and this is your job.
And who did you address that to?
Ms. Ellis.
Okay. And did she say anything in response?
I don't remember. There was a lot of name calling going back and forth between the two and threats, that type of thing. But my primary objective was to get our security guard back in the elevator and off the floor.
And how did you accomplish that?
Repeating myself over and over and over. And I can't remember if I was holding the elevator door open or I've been trying to think about that. I have no idea. I remember pushing the button if it wasn't, but just to try to get the elevator there and get Ms. Ellis back on it.
Did you come between your receptionist and Cardi B, between them on the one hand and Ms. Ellis?
I think to the side.
Okay. What did you tell her to try and get her to move into the elevator?
To stop and to do your job.
Did you say that repeatedly?
Yes.
Did you say it in a loud voice?
Yes.
And what was she doing when you were saying these things?
Yelling and pointing. I think at that point there was enough distance between the parties that there was no longer, any gestures that could be construed as violent.
Okay. And at that point, had the Cardi B and the receptionist gone back into the office, into your office?
Yes, as soon as Miss Ellis stepped back on the elevator, Cardi and Tiara were heading back into my office, or into my office.
At any point, were you face-to-face with Miss Ellis?
Yes,
And can you ask me how close you were?
it was close proximity,
Okay,
within a foot.
okay, within a foot of her face.
Mm-hmm.
And
Yes,
did you see on her face any scratches?
no,
Did you see on her face any cuts?
none,
Did you see on her face any blood?
no,
Did you see any injury at all on her face that day?
none,
And did you see spit or spittle or any other fluid on her, anywhere on her?
no,
During the course of this, did you hear Miss Ellis say something to the effect, and I apologize, "I will fuck your shit up"?
yes,
At any time, did you see Cardi B spit on plaintiff?
no,
Did you see her spit on anyone?
no,
Did you see Cardi B take a swing at plaintiff?
no,
Did you see Cardi B hit plaintiff?
no,
Did you see Cardi B scratch or cut plaintiff with her fingernails?
no,
Did you see Cardi B threaten to get plaintiff fired?
no,
Did you hear Cardi B call plaintiff the N-word? And by that I mean the whole N-I-G-G-E-R.
no,
Did you hear Cardi B call plaintiff fat or poor?
no,
Did you ever see, well, did you see plaintiff, I take it you saw plaintiff hit your receptionist, is that correct?
yes,
At her deposition, plaintiff testified that she was, quote, "just focused on getting downstairs," close quote. Is that consistent with what you saw?
no.
Okay, and why is it not consistent with what you saw?
It took me, I would have guessed 30 to 45 seconds to get her to get back on the elevator.
After you got plaintiff in the elevator, what did you do next?
Went back into my office.
And did you examine Cardi
I saw her that day, yes?
in a patient room?
Yes.
Okay. And did she have 3-inch nails on her fingernails, fingers that day?
No.
Okay. And how is it that you know that?
I make a point of looking at people's fingernails. I have no idea why. It sort of lightens the room when you're doing an exam, when you're about to do a pap smear, to say, oh, that's a really cool color. Where'd you get it? I can kind of tell all of the nail trends in the city. Because it's bizarre that once you see one type of nail polish, then that next 2 months, everyone has it. And it would have just stuck out to me.
To your knowledge, did Cardi B complain to the building about plaintiff's conduct?
No.
Did you take steps to make the building aware of plaintiff's conduct?
Yes.
And what steps did you take?
I called our practice administrator that day, and given what I had witnessed of the conduct of our security guard when I was out there, I said she needs to go. Then my administrator on Monday morning, I think took Tiara down and made a statement for the building, and then the building proceeded to do what they did.
Okay, thank you. Those are all the questions I have for you, sir. Thank you.
All right, cross-examine.
Good afternoon, doctor.
Good afternoon.
You're at 8920 Wilshire Boulevard?
Yes.
Are you aware that I'm across the street from your office at 9025 Wilshire Boulevard?
Nope.
When I approached you outside and I wanted to speak with you, isn't it true that you were unwilling to speak with me? Is that correct?
Yes.
Okay. And when the defense wanted to speak with you, you did talk to them, correct?
Yes.
You even prepared a declaration, and you gave them permission to sign it on your behalf?
Yes.
And you are here because you want to testify in favor of your patient, correct?
I'm here because I'm one of 4 people who were in the hallway that day,
Right.
and I'm here to tell you what I saw.
And you've been, I'm sorry, go ahead.
And I'm just flabbergasted by the allegations
Fair.
that don't seem congruent with what I saw that day.
Right. On how many occasions did you speak with the attorneys from the defense
In person or over the phone?
combined?
In person once, twice, including today. Over the phone 3 times.
What did you talk about that was so important 3 different times?
They wanted to know what I knew. They wanted to see if they could get a hold of Tiara, who no longer works at our practice. That's the nuts and bolts.
Okay. You are a licensed gynecologist in the state of California since 2007?
Yes,
And in your field, your specialty deals with below the waist, correct?
yes.
What is the reason you would think to look at Imani Ellis's face when you have 2 people that are yelling at each other with someone in between? Was there a reason that you were specifically at that time looking at Imani Ellis's face to tell us whether there was a scar, a cut, or anything to her face?
When at that moment, she was closer to the elevator. There probably was about 3-4 feet between the 2. And I got between her and them. And the elevator was directly behind her. So I was making direct eye contact to try to be as assertive as I could.
Okay. Isn't it true that you don't remember what you ate a week ago? Fair?
Objection, Your Honor. So Steve,
This incident happened 2,741 days ago, 7.5 years ago. You agree?
Correct.
In those 7.5 years, did you take any notes of what happened on the day of the incident?
I did not.
Okay. So everything you're telling us right now, from 7.5 years ago, is from your memory of what occurred, correct? And
Correct.
having all these conversations with defense counsel maybe help refresh your recollection, correct?
No.
No?
The majority of solidifying it in my brain over all these years is partially because the people who were involved in it, who were there that day in my office, would recount the story from time to time. And it was a very vivid memory and interaction.
When you got there, Tiara Malcolm, your receptionist, was already outside, correct? Okay.
Yes.
Are you aware that Tiara Malcolm and even Cardi B have testified that for 40 to 50 seconds, you and Tiara Malcolm were not there? Are you aware of that?
objection is characterized the testimony.
I would guess it was shorter than that, but if their recollection is 40 to 50 seconds, I mean, as long as it takes me to go down the hallway and out into the hall, the type of yelling that was taking place was alarming. And so it was like, get there right away. I can't give you an exact time frame, but it wasn't more 40 to 50 seconds.
And different ones?
Over the years,
It's your impression, it's your, well, strike that. It's important to you to help Cardi B's case. You need to see.
to ensure that anybody coming to my office, celebrity or not, doesn't have that type of experience.
Understood. But you had not gotten there until after many things occurred between the 2 of them, correct?
Objection calls for speculation.
Sustained.
Earlier, you testified that you saw Imani Ellis hit your receptionist.
Yes,
You remember seeing that?
yes.
How come your receptionist didn't say that?
Objections.
Sustained.
Are you aware that your receptionist who was facing Imani Ellis did not say that?
Objection.
Are you aware of that at least?
I'm not aware of that.
Did your receptionist ever tell you that Imani Ellis hit her?
Yes, in the recollection of everything back and forth, and then she had a thing on her forehead.
Right.
It was very apparent to me that no hits landed on anybody else except for her, my receptionist.
And your receptionist specifically told you that Imani Ellis hit her, correct?
I saw it.
I understand, but did your
I
receptionist
don't know
tell
that she
you?
remembered it. I mean, I don't. Everyone's adrenaline was kind of elevated, and once we kind of recounted, there's some background as well. We had an attorney visited our office a few times in the weeks after the incident, inquiring what happened and various things, leaving a business card. So we talked about it a lot, and I think we both concluded that the only one who was smacked was her.
Did that receptionist make any type of claim against Miss Imani Ellis?
No.
Why not?
Objection calls for speculation.
Sustained.
In your declaration, you state that on one occasion, plaintiff's counsel left a business card. I'm the plaintiff's counsel. Did I leave a business card in your office?
Objection, Your Honor.
Do you know, I withdraw the question. Do you know if I left a business card in your office?
Objection calls for speculation.
Overruled.
You personally, I do not. It was a male, dark hair, darker beard, and a different receptionist got the business card, who wasn't working that particular Saturday. And I think at one point I came out on a different occasion when this person was came to the check-out desk, not the check-in desk, on a different date, and I said, you need to leave.
Okay. The declaration that you signed yesterday, have you read it?
It was read to me.
Okay.
Your Honor, it's an objection.
Sustained.
Can you look at the photograph in front of you on the left side?
Could you identify it to counsel, please?
Do you see the photograph?
Can you identify the article?
I'm sorry, Your Honor, I don't remember the exhibit number, but it's a photograph of Cardi B from 2018.
Your Honor, it's exhibit 232.
Thank you.
Okay. For the record, exhibit 232. Do you see the photograph?
I do.
Are you aware that this photograph was taken on February 18th of 2024, which was 1 week before
Objection,
the
Your Honor.
incident? Are you aware of that?
Objection, Your Honor.
Sustained.
Do you know when this photograph was taken?
Objection, Your Honor.
Overruled.
No, but it probably was around the time of the incident, I would guess.
And, may I have it back, sir? If you look at the fingernails, since you're a fingernail man, if you look at these fingernails in the photograph, and sorry, I wasn't trying to be rude, I'm just making a joke, if you don't
Fine.
mind. The fingernails that are in this picture, are these the same fingernails that Cardi B was wearing when she entered your office on the date of the incident?
I think so.
Are you sure?
I didn't memorize them, but I know that they weren't 3-inch long with a spear at the end.
But you're not sure if these are the same fingernails, correct?
I believe they are.
Was Cardi B's hair this way when she came to your office, the same way in this photograph here?
Objection, Your Honor. Out of
Sustained.
scope.
Was Cardi B dressed this way when she appeared in your office?
Objection, relevance.
Okay.
Let's go.
When you came out into the hallway, did you hear Cardi B yelling profanities at Miss Ellis?
Yes,
What were some of the words, without going into details? The F word? the
F's
word?
and B's and all of it.
So both sides were yelling at each other?
It was an epic yelling match.
Okay. And when you heard this epic yelling match, it was so loud that you heard it while you were inside of your office? Is that correct?
There's an additional hallway in between the main hallway and the office I was sitting in. And all the way at the south side of the building. Yes, took a lot of energy for me to hear it.
When you walked out of your office, you didn't know what areas of the body Miss Imani Ellis was claiming injuries to at the time, correct?
Objection. Let's
I withdraw it.
Why don't you just ask him a fact check question?
Do you know what areas of the body Imani Ellis, what areas of her body were injured at the time of the incident?
Objection, argumentative, lacks foundation, contrary to all the evidence in the case.
Did you have a reason to focus on any part of Imani Ellis's body when you came out?
No,
So, in your state of mind when you walked out, you walked out, you heard lots of screaming, 3 different women doing something, and you were focused at the whole thing, weren't you?
yes, that was before I asked her to leave multiple times,
Of course.
but face to face.
Right. But when you did come out, you saw 3 different women and your receptionist in between Cardi B and Imani Ellis, correct?
Yes,
And when you were facing that, your focus was not only at Imani Ellis, it was at everybody, correct?
yes,
Okay. And there was a lot of commotion and yelling and screaming and excitement at that very moment, right?
correct.
And for how many seconds, when you first arrived, how much time passed before Imani Ellis went away?
It seemed like a long time. It probably was 45 seconds.
So in those 45 seconds, did you have a chance to examine Miss Imani Ellis?
I didn't examine her, I looked at her.
Okay. Did you specifically look at her face for some reason?
I was looking directly at her face for at least 20 seconds or so,
Okay.
repeating myself over and over and over.
And when you were doing that, you weren't looking for a scar, were you? Or a cut or any kind of damage to her face?
Objection, asked and answered.
Fair?
Sustained.
Do you have any experience in plastic surgery?
Objection, involvement.
You may answer, doctor.
Define plastic surgery.
You're the doctor.
I do cosmetic procedures on the vagina, the vulva, and I also do microneedling with radiofrequency procedures, CO2 laser ablation of things. I don't do the face.
Understood. So, if there was any damage to Miss Imani Ellis's face, if there was any kind of injury to it, would you have known?
I would assume I would see blood or a big scrape or some physical damage.
And when you were out there and you were between the 3 of them, the 3 women, when you were there, and in those 45 seconds, did you see the cut to your receptionist's face at that time, not later?
No,
You didn't see it,
I never looked directly at her until we were back in the office.
but at that time it was there, right? During the 45 seconds, it had already.
Well, sometimes little scratches like that might not show up for a little bit.
What's a little bit?
Well, if I just scratch my hand like this, I might see it out in the sun, 10 minutes later from just erythema.
Okay, so if Imani Ellis got a scratch, she could also develop it 10 minutes later. Fair? You just testified to that. Isn't that true?
Counsel, that's your counsel to tell us what he testified to, but I would object, Your Honor, mischaracterizing testimony. Thank you.
All right, why don't we ask what this witness knows about the incident?
When you spoke to defense counsel 3 times, which attorney was it? Was it Mr. Anderson or Mr. Lamb or Ms. Moore?
Over the phone, Ms. Moore.
Every time?
Probably, yes.
And for you to come down here and testify, you had to at least cancel half the day of your work, correct?
I canceled my whole afternoon on a day's notice.
Are you getting paid to be here?
No.
Why are you testifying if you're not being paid? Were you subpoenaed?
I was not.
So you came voluntarily?
I did.
And they believed that you would appear here today in court with no subpoena. That's how confident they were that you were here to help them, correct?
Assistant. Any other questions?
When Cardi B came into your office after the incident, what did she tell you?
I apologized. She was more calm than I thought she would be. She didn't complain about the incident or to me afterwards, which I was kind of surprised about as well. I would have been upset if I were the client. And then we proceeded to help her with what she came in for.
Could it be that she didn't apologize because she was the one that assaulted Miss Ellis?
Objection, Mrs. Speaker.
Assistant.
Did you
How
have...
about stopping with the cookies and just ask him what happened, what he saw, what he heard, what he smelled?
Yes, sir. Can you look at the photograph again? The one that you have in front of you, Exhibit 231 or 232? This one. In the photograph, you will see nails, fingernails with some rhinestones on top of them. Do you remember seeing rhinestones on Cardi B's fingernails when she came into your office on the date of the incident?
Objection, mischaracterizes the evidence and the photograph.
Yeah, I mean, they were decorative. She was not made up. She was in plain clothing, but the nails were done.
And those rhinestones, were they sharp and pointy?
I think rhinestones in general have rough edges.
And they're sharp and pointy and with rough edges?
On the back, on the front side of the nail, on the top of the nail, they look like they project.
And I see that you're wearing glasses. Do you wear them, were you wearing your glasses at the time of the incident?
I'm 99% sure I wasn't, because up until a couple of years ago, I just wore contacts.
Were you wearing contacts at the time of the incident?
Yes.
So there was no vision issues?
No.
I have no further questions. Thank you, Doctor.
All right, Leroy?
Yes, Your Honor, just a few. I guess I'll do it from here. Doctor, you said that you were one of 4 people in the hallway, so that's you, Cardi B, Ms. Malcolm, and the plaintiff?
Correct.
Was there anyone else in the hallway?
No.
Is it correct, the counsel asked you about cuts, bleeding. Do cuts and scratches tend to bleed more if they're on the face than if they're on some other part of the body?
Objection calls for expert opinion outside the scope of this witness.
Oh,
Can you repeat the question?
Sure. Is there a difference in the tendency to bleed if the cut or scratch is on your forehead or cheek than if it's on another part of your body?
The head face is generally, has greater blood flow,
Okay.
smaller blood vessels.
Yeah. As a fingernail guy, are you Have you seen fingernails where the rhinestones are flat? They're actually just little inserts. They look like rhinestones, but they're flat. Have you seen
Objection
those?
calls for speculation.
Overruled.
I have seen objects put into, I would guess, it's an acrylic nail, and somewhat buried. I have seen that.
Yeah. Do you have any recollection now, 7.5 years later, whether the rhinestones in that photograph and apparently on Cardi's fingernails were actually three-dimensional or were flat?
Objection calls for expert opinion.
Overruled.
No recollection.
Um, 1 second. No further questions. Thank you very much, Doctor.
All right, recross.
No further questions, thank you.
All right, any questions from the jury? All right, this witness be excused.
Thank you.
All right, thank you, doctor. All right, does the defense have any more witnesses to call?
No, Your Honor.
Defense rests.
Yes, Your Honor.
All right, does plaintiff rest?
Yes, Your Honor.
All right, folks, that concludes the presentation of evidence. We have some work to do on jury instructions, but there's a number of jury instructions that I can read now. So rather than do those on Tuesday, I'm going to read a set of jury instructions. There will be additional jury instructions read on Tuesday. The order in which I read these instructions is not important, so to the extent that I read some today and some on Tuesday, pay no attention to the fact that they are given at different times. Does not mean that any have any more significant meaning than any of the others. And the parties have stipulated that the jury instructions do not need to be recorded by the court reporter, so at this time she can stop doing so. All right, and again, I'll read these quickly. They'll be available to you in the jury room. Members of the jury, you have now heard all the evidence and will hear the closing arguments of the attorneys. It is my duty to instruct you on the law that applies to this case. You must follow these instructions as well as those that I previously gave you. You have a copy of my instructions with you when you go to the jury room to deliberate. You must decide what the facts are. The device, the internet, any internet service, any text or instant messaging service, any internet chat room, blog, or website, including social networking websites, online diaries, to send or receive information to or from anyone about this case or your experience as a juror until after you've been discharged from your jury duty. Do not investigate the case or conduct any experiments. Do not contact anyone to assist you, such as a family accountant, doctor, or lawyer. Do not visit or view the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. All jurors must see or hear the same evidence at the same time. Do not read, listen to, or watch any news accounts of this trial. You must not let bias, sympathy, prejudice, or public opinion. If you violate any of these prohibitions on communications and research, including prohibitions on electronic communications and research, you may be held in contempt of court or face other sanctions. That means you may have to serve time in jail, pay a fine, or face other punishment for that violation. I will now tell you the law that you must follow to reach your verdict. You must follow the law exactly as I give it to you, even if you disagree with it. If the attorneys have said anything different about what the law means, you must follow what I say. In reaching your verdict, do not guess what I think your verdict should be from something I may have said or done. Pay careful attention to all the instructions that I give you. All the instructions are important because together they state the law that you'll use in this case. You must consider all the instructions together. After you've decided what the facts are, you may find that some of the instructions do not apply. In that case, follow the instructions that do apply and use them together with the facts to reach your verdict. If I repeat any ideas or rules of law during my instructions, that does not mean that these ideas or rules are more important than the others. In addition, the order in which the instructions are given does not make any difference. Most of the instructions are typed, however, some handwritten or typewritten notes may have been added, and some words may have been deleted. Do not discuss or consider why words may have been added or deleted. Please treat all the words the same, no matter what their format. Simply accept the instruction in its final form. You may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. You may consider whether one party intentionally concealed or destroyed evidence. If you decide that a party did so, you may decide that the evidence would have been unfavorable to that party. If a party failed to explain or deny evidence against them when they could reasonably have done so based on what they knew, you may consider their failure to explain or deny in evaluating that evidence. It is up to you to decide the meaning and importance of the failure to deny evidence against the party. During the trial, you received deposition testimony that was read from deposition transcripts or shown by video. A deposition is the testimony taken of a person before trial. At a deposition, the person is sworn to tell the truth and is questioned by the attorneys. You must consider the deposition testimony that was presented to you in the same way as you consider testimony given in court. Before trial, each party has the right to ask the other parties to answer written questions. These questions are called interrogatories. Questions and answers that were read to you the same as if the questions and answers had been given in court. A party may offer into evidence any oral or written statement made by an opposing party outside the courtroom. When you evaluate the evidence of such a statement, you must consider these questions. Do you believe that the party actually made the statement? If you do not believe that the party made the statement, you may not consider the statement at all. If you believe that the statement was made, do you believe it was reported accurately? You should view testimony about an oral statement made by a party outside the courtroom with caution. During the trial, you heard testimony from expert witnesses. The law allows an expert to state opinions about matters in the expert's field of expertise, even if the expert has not witnessed any of the events involved in the trial. You do not have to accept an expert's opinion. As with other witnesses, it is up to you to decide whether you believe the expert's testimony and choose to use it as the basis for your decision. You may believe all, part, or none of an expert's testimony. In deciding whether to believe an expert's testimony, you should consider the expert's training and experience, the facts the expert relied on, and the reason for the expert's opinions. The law allows expert witnesses to be asked questions that are based on assumed facts. These are sometimes called hypothetical questions. In determining the weight to give the expert's opinion that is based on the assumed facts, you should consider whether the assumed facts are true. If the expert witnesses disagreed with one another, you should weigh each opinion against the others. You should examine the reasons given for each opinion and the facts or other matters that each witness relied on. You may also compare the expert's qualifications. A witness who was not testifying as an expert gave an opinion during the trial. You may, but are not required to accept that opinion. You may give the opinion whatever weight you think it is appropriate. Consider the extent of the witness's opportunity to perceive the matters on which the opinion is based, the reasons the witness gave for the opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether the information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Ms. Ellis claims that she was harmed by Ms. Almanzar's negligence. To establish this claim, Ms. Ellis must prove all of the following: that defendant was negligent, that plaintiff was harmed, and that defendant's negligence was a substantial factor in causing plaintiff's harm. Negligence is the failure to use reasonable care to prevent harm to oneself or to others. A person can be negligent by acting or failing to act. A person is negligent if that person does something that a reasonably careful person would not do in the same situation, or fails to do something that a reasonably careful person would do in the same situation. You must decide how a reasonably careful person would have acted in defendant's situation. Causation. A substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. Conduct is not a substantial factor in causing harm if the same harm would have occurred without that conduct. Ms. Ellis claims that Ms. Almanzar committed a battery. To establish this claim, plaintiff must prove all the following: the defendant touched plaintiff with the intent to harm or offend her, that plaintiff did not consent to the touching, that plaintiff was harmed or offended by defendant's conduct, and that a reasonable person in plaintiff's situation would have been offended by the touching. A plaintiff may express consent by words or acts that are reasonably understood by another person as consent. A plaintiff may also express consent by silence or inaction if a reasonable person would understand that the silence or inaction intended to indicate consent. Ms. Ellis claims that Ms. Salmanzar's conduct caused Ms. Ellis to suffer severe emotional distress. To establish this claim, Ms. Ellis must prove all of the following. That defendant's conduct was outrageous, that defendant intended to cause plaintiff emotional distress, that plaintiff suffered severe emotional distress, and that defendant's conduct was a substantial factor in causing plaintiff's severe emotional distress. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, and shame. Severe emotional distress is not mild or brief. It must be so substantial or long-lasting that no reasonable person in a civilized society should be expected to bear it. Plaintiff is not required to prove physical injury to recover damages for severe emotional distress. If you decide that plaintiff has proved her claim against defendant, you must also decide how much money will reasonably compensate Ms. Ellis for the harm. This compensation is called damages. The amount of damages must include an award for each item of harm that was caused by defendant's wrongful conduct, even if the particular harm could not have been anticipated. Ms. Ellis does not have to prove the exact amount of damages that will provide reasonable compensation for the harm. However, you must not speculate or guess in awarding damages. The damages claimed by plaintiff are, for the harm caused by defendant fall into two categories called economic and non-economic damages. You'll be asked in the verdict form to state the two categories of damages separately. The following are the specific items of economic damages claimed by Ms. Ellis: past and future medical expenses. The following are the specific items of non-economic damages claimed by Ms. Ellis: physical pain, mental suffering, and emotional distress. The arguments of the attorneys are not evidence of damages. Your award must be based on your reasoned judgment to the testimony of the witnesses and the other evidence that has been admitted during the trial. You must not consider or include as part of any award attorney's fees or expenses that the parties incurred in bringing or defending this lawsuit. When you go to the jury room, the first thing you should do is choose the presiding juror. The presiding juror should see to it that your discussions are orderly and that everyone has a fair chance to be heard. It is your duty to talk with one another in the jury room and to consider the views of all the jurors. Each of you must decide the case for yourself, but only after you have considered the evidence with the other members of the jury. Feel free to change your mind if you are convinced that your position should be different. You should all try to agree, but do not give up your honest beliefs just because others think differently. Please do not state your opinions too strongly at the beginning of your deliberations or immediately announce how you plan to vote, as it may interfere with an open discussion. Keep an open mind so that you and your fellow jurors can easily share ideas about the case. You should use your common sense and experience in deciding whether testimony is true and accurate. However, during your deliberations, do not make any statement or provide any information to other jurors based on any special training or unique personal experiences that you may have had related to matters involved in this case. Not a part of the evidence received in this case. Sometimes jurors disagree or have questions about the evidence or about what the witnesses said in their testimony. If that happens, you may ask to have testimony read back to you or ask to see any exhibits admitted into evidence that have not already been provided to you. Also, jurors may need further explanation about the laws that apply to the case. If this happens during your deliberations, write down your questions and give them to the bailiff or the courtroom attendant. I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will do my best to answer them. When you write me a note, do not tell me how you voted on an issue until I ask for this information in open court. Your decision must be based on your personal evaluation of the evidence presented in the case. Each of you may be asked in open court how you voted on each question. While I know you would not do this, I'm required to advise you that you must not base your decision on chance, such as flip of a coin. If you decide to award damages, you may not agree in advance to simply add up the amounts each juror thinks is right, and then without further deliberations, make the average or verdict. You may take breaks, but do not discuss the case with anyone, including each other, until all of you are back in the jury room. If you have taken notes during the trial, you may take your notebooks with you into the jury room. You may use your notes only to help you remember what happened during the trial. Your independent recollection of the evidence should govern your verdict. You should not allow yourself to be influenced by the notes of other jurors if those notes differ from what you remember. At the end of the trial, your notes will be collected and destroyed. You may request in writing that trial testimony be read to you. I will have the court reporter read the testimony to you. You may request that all or a part of a witness's testimony be read. Your request should be as specific as possible. It will be helpful if you can state the name of the witness, the subject of the testimony you would like to have read, and the name of the attorney or attorneys asking the questions when the testimony was given. The court reporter is not permitted to talk with you when she is reading the testimony you have requested. While the court reporter is reading the testimony, you may not deliberate or discuss the case. You may not ask the court reporter to read testimony that was not specifically mentioned in a written request. If your notes differ from the testimony, you must accept the court reporter's record as accurate. And one footnote there, just as it takes us some time to respond to your questions, it also takes us time to isolate the testimony that you're requesting, so please continue deliberating while you're waiting for a readback. I will give you a special verdict form with questions you must answer. I have already instructed you on the law that you are to use in answering these questions. You must follow my instructions and the form carefully. You must consider each question separately. Although you may discuss the evidence and the issues to be decided in any order, you must answer the questions on the verdict form in the order they appear. After you answer a question, the form tells you what to do next. At least 9 of you must agree on an answer before you can move on to the next question. However, the same 9 or more people do not have to agree on each answer. All 12 of you must deliberate on and answer each question regardless of how you voted on any earlier question. Unless the verdict form tells all 12 jurors to stop and answer no further questions, each juror must deliberate and vote on all the remaining questions. When you have finished filling out the form, your presiding juror must write the date and sign it at the bottom of the last page, and then notify the bailiff that you are ready to present your verdict in the courtroom. To the alternate juror, the jury will begin deliberating after closing arguments, but you are still an alternate juror and are still bound by my earlier instructions about your conduct. Until the jury is discharged, do not talk about the case or about any of the people or any of the subject involved in it with anyone, and not even your family or friends, and not even with the other jurors. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form and express an opinion about the issues in the case unless you are substituted for one of the deliberating jurors. In this case, I've exercised my right to comment on the evidence. However, you, the jury, are the exclusive judges of all questions of fact and the credibility of the witnesses. You are free to completely ignore my comments on the evidence and to reach whatever verdict you believe to be correct, even if it is contrary to any or all of those comments. After your verdict is read in open court, you may be asked individually to indicate whether the verdict expresses your personal vote. This is referred to as polling the jury and is done to ensure that at least 9 jurors have agreed to each decision. The verdict form that you will receive the verdict form that you will receive asks you to answer several questions. You must vote separately on each question. Although 9 or more jurors must agree on each answer, it does not have to be the same 9 for each answer. Therefore, it is important for each of you to remember how you have voted on each question, so that if the jury is polled, each of you will be able to answer accurately about how you have voted. And we're actually going to give you your own copy of the verdict form, so please keep track of your own votes on the verdict form. The verdict form, the final verdict form that the jury foreman will have will be the only one that's turned in, but please keep track of your votes on the verdict form that you're given for your own copy. If during the trial any of you had a question that you believe should be asked of a witness, you are instructed to write out the question and provide it to me through my courtroom staff. If a question was asked, or I decided whether the question could be asked. If a question was asked and answered, you are to consider the answer as you would any other evidence received in the trial. Do not give the answer any greater or lesser weight because it was initiated by a jury question. If a question was not asked, do not speculate as to what the answer might have been or why it was not asked. There are many legal reasons why a suggested question cannot be asked of a witness. Give the question no further consideration. During the trial, materials may have been shown to you to help explain testimony or other evidence in the case. Some of these materials may have been admitted into evidence, and you'll be able to review them during your deliberations. Other materials may have also been shown to you during the trial, but they have not been admitted into evidence. You will not be able to review them during your deliberations because they are not themselves evidence of any evidence or proof of any facts. You may, however, consider the testimony given in connection with those materials. All right, as I indicated, there's going to be some additional jury instructions that are going to be read on Tuesday. Why don't we plan on starting closing arguments at 9:45 on Tuesday? I need to meet with the attorneys at 9 o'clock, and while I think we'll be done by 9:30 to finalize everything, I don't want you to be waiting in the hallway. So let's plan on 9:45 on Tuesday. My expectation is we will be done with closing arguments before lunch, and that you will have the case to deliberate on after lunch on Tuesday. There are several causes of action, and so I do anticipate that it's going to take a bit of time to deliberate on each cause of action. And so I would, have a pretty strong feeling that it is likely that you will also be here on Wednesday to finish deliberating. So at present, we're definitely going to be here Tuesday at 9:45. You can anticipate that you're not going to finish deliberating by the end of the day on Tuesday, and that you'll be here at least Wednesday morning to finish deliberations and to render your verdict. And then you guys will know how things are going as to how much longer into Wednesday or potentially Thursday things will take. Okay, any questions about that? Please do your absolute very best to avoid any media. I know that there has been some coverage of it. If you happen to see something, just go ahead and turn it off, turn it away, whatever it may be. We don't want you to be influenced by any of the media coverage, okay? All right, we'll see you on Tuesday, 9:45. Have a good Labor Day weekend.
Now I got to turn my mic on. Yeah, so they're doing closing argument on Tuesday because Monday is a holiday. And everybody gonna be having their last cookout. You know how that go. So that's it. That's all, guys. Crystal, thank you so much for modding. Definitely will meet you in the DMs. And yeah, thanks for sticking it out with me. We'll resume this on Tuesday morning because I want to hear everything. And I think this is gonna be a quick, you know what, not guilty, and have that girl pay. Like, Carter didn't get you fired. The doctor did because he called to let them know. But anyway, guys, love y'all. Thank you to all my new subscribers. You guys are awesome. Thank you so much for subscribing. I'm going to try to always bring you good, clean content. I will talk to y'all in the next one. All right, talk to y'all later. Bye. Gotta go edit this video.